Right now.
We are live.
We're live. Okay. We're trying to get together here. Welcome, folks. This is November 28th, Tuesday. This is Joint Justice Oversight Committee. We have with us on Zoom Senator Dick Sears, who is the chair of the committee. He will be running the committee per se in terms of how he can when you're on Zoom, but I will be running the meeting here. And so we do have the chair and vice chair of the committees here. We're going to spend some time this morning getting review of the home detention program, because one of the charges for us is to look at this program and make a recommendation in terms of should the program be continued, should it be adjusted, should it not be continued. As a little bit of background, last session, this past session in January, the administration proposed repealing this particular program. And the House Corrections and Institutions Committee looked at this, took some testimony, made some adjustments to the law to see if we could have more participants in this program and make it more aware to the judges that this is an option. And then it's up to us to do a review of this and submit some recommendations to the standing committees come this next session. So in conversations with our legislative counsel, with Ben Novogrodsky, we really needed a background of the law. So I wanted Ben to walk through what the statute is so folks can come up to speed. I think this law was probably about 15 years ago, maybe 20 at this rate. I'm not that long ago, 12. And I know Senator Sears has worked a lot on this at the beginning, and as we did on the House side. So Ben, I'm going to turn it over to you.
Sure.
I'm assuming that we have a document on our webpage.
Yep.
Yeah, so this would be, I believe, so for the record, Ben Novogrodsky from the Office of Legislative Counsel. My understanding, Peggy, is that you posted, it's Act 78. The relevant portions are sections E 338.1 and .2. Point 1 outlines the change that was made to the home detention program in the big bill, which included the explicitly includes or permits for the use of passive monitoring, which I'll let the Department of Corrections get into what that really means. And then in section 338.2 is the charge for the review of the program. So reviewing the program under 13 VSA 7554B, which is its governing statute, including its historical and current use, defendant eligibility criteria, and any potential changes to the types of crimes for which it can be used. So going into home detention itself, as I say, it's governed by 13 VSA 7554B, and home detention applies to defendants who have been detained at a correctional facility for more than 7 days, or can apply, should I say, to defendants who've been detained at a correctional facility for more than 7 days for lack of bail. It's defined as a program of confinement and supervision that restricts a defendant to a pre-approved residence continuously, except for authorized absences such as for work, school, or treatment. At its essence, home detention is designed for detainees who have traditionally remained incarcerated for lack of bail, and is aligned with this department's stated policy to supervise individuals in its custody in the least restrictive environment while balancing public safety concerns. So procedurally, how does this work in practice? Procedurally, the defendant, the department itself, or the court can request a review of the status of a pretrial detainee for an inability to pay bail after it has been set by the judge. The review is scheduled upon receipt of a report from the department determining that the proposed residence for the individual to live at is suitable for the use of electronic monitoring. So things like GPS ankle bracelets or alcohol sensing bracelets, if appropriate. So at arraignment or at a subsequent hearing, the court may order the defendant to be released for home detention as long as the court finds that home detention will reasonably secure the defendant's appearance in court when required and the proposed residence is suitable. So in making that determination, the court considers a few factors. One, the nature of the offense charged. Two, the defendant's prior convictions, history of violence, medical and mental health needs, history of supervision, and risk of flight. And third, any risk or undue burden to other persons who reside at the proposed residence, risk to third parties, or risk to public safety that may result from the placement itself. If the court refers someone to home detention prior to the court's decision, it will order the department through the applicable field site to conduct an investigation of the residence's suitability for home detention. This includes determining if the residence supports the use of electronic monitoring devices, either through a cellular or landline. If neither are available, the department will inform the court that if a landline is installed, the site would be approved. So that seems to be really the contingent issues, that sort of connectivity. But again, I'll refer to the department on how the machinations of that. So this report needs to be submitted to the court within 7 days of the court issuing the order directing the department to do the investigation. And then if the court orders home detention, the court will issue what is called a home detention bail minimus, which includes the defendant's home detention conditions, approved appointments and schedules, and a bail amount. A Department of Corrections referral occurs after an inmate is screened by a correctional facility for potential home detention placement within 5 days of intake. So this is another way that it can get to the court. This screening is maintained in the department's offender management system. The facility completes a department review request form for any detainee that meets certain requirements, which include being detained for a non-listed crime, having a Vermont residence, so basically meaning any place in Vermont for the individual to go to. And that the inmate has, again, cell or landline service, approved for the defendant to live there if housing is subsidized, approved by DCF if there's a reasonable belief that the defendant presents a risk of harm to children at the residence, or if there are minors, that the defendant does not pose a risk of sexual abuse or physical injury to them. So these are, again, all things that kind of go into that determination. Third, if a detainee has been under DOC supervision within the past 3 years, additional requirements may apply, showing a low to moderate risk assessment score, successful completion of community supervision, or both. So once completed, the request for review is uploaded to the offender management system and submitted to the court clerk. The court will review the application, and after its review is done, order the department to conduct that residency suitability investigation that I explained a little bit before. So once a detainee is released to home detention, the department does a home detention intake that again updates to OMS concerning the defendant's address, photos, electronic monitoring devices that are assigned to the defendant's review and acknowledgement of the conditions, and any other pertinent information. The department assigns a community corrections officer who's responsible for the day-to-day supervision of the defendant, and this can include responsibility for providing electronic monitoring surveillance, reviewing monitoring reports, attending court hearings, approving schedule changes, and any other related responsibilities. If there is a violation of the home detention order, staff can return the defendant to a correctional facility and must notify the court when it does so. The same goes for an unapproved absence from home detention as well. The department essentially has sole discretion to make any changes to the schedule, and a defendant under home detention is considered officially in custody of the department with conditions set by the court. And again, the department can revoke home detention for those unauthorized absences or failure to comply with conditions. Again, which would return them to a correctional facility. Another way for a defendant to get out of home detention, so to speak, is for them to post bail and be released. And there are always due process considerations in this process. similar to those applying to furlough violations. And that's one that the department adheres to if there is a return to a facility process that's initiated. So that is an overview of the program. Happy to answer any questions if I can.
So when the program was put in, the intent of home detention, these are for folks who have not been sentenced.
Right.
This is a detainee, what we would call a detainee. And it was a mechanism that we put in place 10, 12, 15 years ago so that we would not be taking up a corrections bed for a detainee. And for some folks that would qualify, they would be able to be a detainee, but be able to be at home during that status with proper supervision. And the home had to be approved by DOC, but it really had to come from the courts. The courts could require home detention, or it could also come from DOC and the offender. And this is where we were seeing a problem last session, is no one was requesting this. And I think we've only had maybe 8 people, 10 people. It's been very small, but the goal was not to take up a hard corrections bed for detainees, not for all of them, but for a select few, to be able to be housed at home. So the administration proposed, had some folks from the committee come in a little bit late here, but the administration proposed back this past session in January, because the numbers were so low in terms of the numbers of folks who were participating in the home detention program, they proposed to repeal the program. And there was concern of repealing this program because our detainee population right now in corrections is about 500. That's the highest. It's usually we're around 300. So right now it's about 500, I think.
430 state and
430 state.
for state detainees, I
And
think.
how many feds?
5 total detainees, something like we just looked at it.
Okay. So the detainee population is continually going up. So this was a tool to take the pressure off of our correctional facilities. So the question is, do we keep the program? Do we tweak it? And I think it's really a time for members to ask questions in terms of what is the program, how does it operate, and what is it all about? Because this is new for many of you, I think. Bob?
This is new for me. Thanks, Ben. A question as to the eligibility for the program. Is this just for misdemeanor offenders, violent, are felony offenders or non-violent felonies? Who's eligible for this program?
The eligibility. What Mr. Cook said is right to a degree, whatever the court says, but it has to be a non-listed crime. So those are things I could, but I think that the defendant eligibility is broader than that, but I can't give you the specifics. It might be a better question for the department or maybe for Judge Stoney.
And it's for people who, this is where I want some clarity. If a person has bail, they would qualify or not.
So it's everybody basically that is subject to bail that can't pay. Once they make bail,
Right.
they're out.
But if someone is being held without bail, they would not qualify, or would they?
They would not, I don't believe.
Right. So for folks that bail is required and they can't make bail, home detention is an option.
Right. And I think it's worth noting that with the exception of, sort of the constitutional limitations, almost everybody is subject to bail in the state. So there are 3 exceptions for life imprisonment, awaiting an appeal or sentence, or basically a violent crime where evidence of guilt is great. Those are the 3 exceptions where people wouldn't be subject to bail.
Martin?
So can home detention be a condition of release? Or is that,
Well, home detention is its own program, but you might be getting at where if somebody is released under the responsibility of, like, say, a responsible adult or responsible organization, they're kind of related, but they're different. You know, in the case where someone would be released to a responsible adult, that would basically be someone essentially accepting responsibility for the defendant and making sure that they adhere to their conditions, because they themselves could get in trouble for a violation at that point. But that's different than home detention, but.
right, no, yeah, I understand, yeah, and I'm just wondering, I mean, is that, or would that run into constitutional issues? Because, so somebody who's not a risk of flight, but for public safety reasons, you want to have a condition of release that's pretty tight.
Right.
Could the condition of release be home detention?
Well, home detention is tied to bail. So, and the primary purpose of bail.
So forgetting about the the law we have right now, I mean, if we wanted to try to expand, which kind of in my view, we should be trying to expand home detention, not get rid of it. Is that one path, but would that run into constitutional issues? And I'm not asking you to know off the top of your head.
Potentially, because right now, since it is tied to bail and public safety isn't the primary purpose of bail, I think there could be constitutional issues.
Right.
It would need to be very particularized. But I need to do some.
I know what you're asking. I know if it wasn't connected to bail, because if you go to the statute, it is Title 13, Chapter 229.
Right.
If you go to the full chapter, the program is for a defendant who is detained pretrial in a correctional facility for inability to pay bail after bail has been set. So if we got rid of that connection, could it be made as part of a condition of release?
Well,
That's more your question, right, Mark?
Yeah, that is my question, if that's.
that's one that I would need to do more research on,
Yeah.
but my initial instinct is with this whole analysis, it's always sort of bail first and then public safety second. So if the conditions of bail were deemed insufficient to protect the public, that's where you get into the conditions of release at that point. So potentially, but the other thing too is that, you know, you're talking about restricting someone's liberty. Even though it's less so than being in a correctional facility, there are due process concerns with that and constitutional concerns because they're still being confined.
That's the heart of my question right
Yeah.
there. Yeah, is if that can be, you know, if there can be sufficient due process in that
I
situation.
need to do research.
Yeah, I wasn't expecting that answer off the top of your head.
So Senator Sears has a question.
Yeah, I guess I have a comment and a question, Ben. The comment is that it's little used, but part of that is because of the narrow group that it's aimed at. And along with Representative Lamont, I'm thinking that we should look at how to expand it. But the problem is, if somebody's released with conditions of release, corrections doesn't supervise them, and nobody really holds them accountable. And we have a system, well, judges can, I guess, but it seems like we have a system that where it's built in to not have corrections or anyone supervising people that are out on conditions of release. And that's part of our problem in my mind. And corrections is supervising people that are on home detention, and I can understand why they don't want to do that. I mean, they've already got enough things that they have to worry about, particularly in probation, parole, et cetera, et cetera. So I'm wondering if it were taking the connection to bail out of the question, and if it's the best thing for society and best thing for the offender, if use of home detention or monitoring system wouldn't that be advisable. When it started, the sheriff in Windham County at the time, and I can't remember his name, pretty much ran the program with the monitoring out of Windham County Sheriff's Office. And I know that a number of cases were used in Bennington. One was even a domestic violence case where the guy was able to keep his job, continue to pay child support, et cetera, and did well on the home detention, and it minimized the sentence. Everybody agreed. So I think it has value. The question is who has to supervise and who has to be responsible for the monitoring. And that's where we come into the problem. That, once that Windham County project was gone, it seems like that this monitoring just changed and we didn't use it. We stopped using it.
And I think the senator has put out some really good points. I mean, who monitors this? And what are the conditions as well?
That was actually my question, looking at where the supervision is taking place during the detention process. Even with electronic monitoring, of course, there's restricted freedoms. So or with supervision, the ability to carry out one's life without being of harm to self or others, I think is really important to consider. And the question I have is it public safety's or DOC's responsibility to supervise at this stage when folks are in detention? Are there other community services such as we have for folks with mental health issues? So just to raise a more general question, I think I'm pleased. I'm very happy that Senator Sears spoke up because I was going to ask, what's the supervision process look like right now?
We're going to go
Yeah,
to DOC.
I'm sure we'll hear, but maybe we haven't really thoroughly set this up so that it's appealing and useful to everyone involved. You can't just, it seems like an added layer on to whomever you're placing it at this point or has been placed, and that it's not being used because it feels either superfluous or more than can be carried out. So I just need some answers to supervision and other questions, and thanks, Ben.
Yeah, well, and as far as for the home detention program, I mean, right now in its current iteration, these people, if they weren't supervised by the department through home detention, they'd be incarcerated, so the department would be supervising them anyway. So I wasn't here when the law was initially passed, but that could explain the policy reason why it's DOC supervising them in the home detention program. But ultimately, as far as conditions of release in general, it's the court that sort of, I mean, nobody oversees them day to day unless they have a responsible adult or some organization like that. But the court is the accountability structure when it comes to conditions of release in the prosecutor.
Thank you.
Keisha?
I have a question and a comment. My question is, similarly to other things in court, like really from abuse orders, et cetera, would it also be fair to say nobody's going into the home first to certify that they don't have firearms or that they don't have they're not breaking other conditions?
Well, I would defer to the department as far as what they're,
We're going to have the.
but there is an investigation that they do about the suitability.
They do, okay, I might have missed that. My comment is, I am very interested in the subject. I'm probably going to be in and out a little bit because of the unfolding crisis in Burlington and just managing some things. So I apologize for that in advance, but I think I might step out and call Senator Lunch's office. So I'll be in and out. I do apologize.
Other questions? Because we are going to move on to DOC as well as judge zoning for the courts. So some of this conversation is good because this is something we should make as a recommendation to the standing committees to take a look at. For that, like who is supervising, how does this play into conditions of release? And bail, if we disassociate it with bail, how does that impact constitutionally? So those are some of the recommendations we could make. Bail. Thank you, Ben. It's fun.
Morning, for the record, Dale Crook, I'm the Director of Field Services at the Vermont Department of Corrections. I've been in this position 14 years, and most of that we've had home detention. So I was there from the very beginning. I think the last session was probably the fourth time we have tweaked it, I think is a good way to say, with it. So Ben did a great job of kind of explaining the program. I guess right now I'll just start off and kind of give you what we have right now and some data, and then I'll answer any questions. I have the entire historical knowledge, the best that I can remember, because it's been a while. So currently today we have 6 people on home detention. Out of those 6 people, we have 1 on for attempted murder, and the other 5 are on for other violent serious offenses, mostly aggravated domestic assaults and aggravated assaults, along with other charges, but those are the 6 we currently have on right now. So between January of 21 and November 26th of 23, so a couple of days ago, we've had 39 total home detention cases with an average length of 163 days. In 2021, we had 18 home detention cases start. In 22, we had 14 home detention cases start. And so far this year, we've had 11 home detention cases start. In August, with the changes in the last legislative session, the department did make a request to repeal it because of the low number. At the time, I think we had 12 on, but it was also a cost-saving measure. Previous legislative sessions before, we made a recommendation to have home detention repealed, and the money was removed for our budget, but home detention stayed. So at the time, it cost us roughly $200,000 per year to run home detention before the change. The big change for the department was the shift from active electronic monitoring to passive. And it's kind of what it is. Active is if you step, out of the box, so to speak, we're notified immediately, and then we respond immediately. It was a 24/7 program when it was active, and that is really where the cost came from, because we don't have staff in the field on 24/7. So we had to have systems in place where we put folks are called standby is a status in the contract, and they got paid to be able to respond if something went off. So we had to have that in every county to be able to respond to any emergencies when it was active. With a shift to passive, we don't have to have that, and it did reduce our cost dramatically. And what passive is kind of what it is we check every day. We have staff come in. They check everyone on everyone on electronic monitoring to see that they're in compliance with their restrictions. The passive is what we use for our general probation, parole, furlough, supervision, EM. So we're not doing anything more or less than what we do with our current population on home detention.
So, Dale, can I just interrupt you here? Who puts on the restrictions? Is
The
the
court.
courts?
So the department has a very small part to play in this. One of it is when we get the referral for the investigation is, does the residents support electronic monitoring? Can we actually use electronic monitoring? That is really, you have to have, that's embedded in the statute, right? Home detention is supervision through electronic monitoring. And that's the only thing we say yes or no to. Historically, we had more, we'd have more influence on the decisions we made. The house isn't good, it's near these people, or you have children, and then that was way early, and we're saying, nope, our only responsibility is electronic monitoring. Everything else falls to the court. So we are really an agent of the court in this role. Since August of this year, we've had 18 referrals that the department has made to the court for home detention review. Since August 1 of this year, the department has received 2 home detention investigations in August, and that has been it. So since August, we've only had 2 referrals to look into investigation.
So you've had, since August, you've had 18 referrals that DOC made
Is made to the court.
to the courts, and of that, only 2 got referred to home detention?
Not necessarily of those 18. We've had 2 referrals for investigation from the courts. So that could be from whoever can refer to the court for home detention.
So how many of those 18, and then of those 2, do you know how many actually went into the home detention program?
Of the ones we referred, I do not. I just know that we made that many referrals and we've had 2 investigations. We don't link like where they go.
So when you say you had 2 investigations, does that mean they went to home detention, those 2?
I don't know if they made it or not, but we had 2 referrals for investigations. I'm guessing that they've probably been on. I don't know if those individual 2 were accepted or not.
So when you do an investigation, what exactly is it that you're looking for? Is it the list that the court gives you, or?
When we have a referral for an investigation for home detention, the primary responsibility of our officers is to go to the residents, make sure the residence kind of exists, and can we use electronic monitoring?
Okay.
And that's it. Everything else is kind of set by the court. The court will set absences from home, like if you need to go to the doctor or work. We can adjust those schedules, but we won't add something that the court hasn't already added. So if someone gets placed on home detention and they don't have a job, we won't add a job to the home detention. But if they have a job and they go from Monday, Tuesday off to Wednesday, Thursday, we'll make those adjustments. Any questions? I think Ben did a good job of kind of explaining all the processes. Yes, sir.
Thanks, Bill. Just so I can understand what's going on. So DOC is moving to eliminate this program. Is that correct?
That was a request last year, yes.
And it's because of the cost of roughly $200,000?
Well, at the time, before we made the change, we had active monitoring. And with active monitoring, we had to be able to respond 24/7. And we had to have staff available to respond 24/7. And that is where the cost was driven from. Now that we moved to passive, that cost has been dramatically reduced.
So I guess my second part is an A and B type thing here. So if the $200,000 was reinstated, would that meet with satisfaction from DOC? But if not, is the program presently working? And if they were incarcerated rather than being on this program, what would that cost the state?
Probably
We'd have-
100,000.
I don't have those. I'm not the finance person, but it would be whatever the marginal cost of one more person in one of our facilities.
So can we assume that 18 individuals would exceed the cost of $200,000 if they were incarcerated?
Oh, probably.
Okay.
Depends how long they'd be incarcerated before they go to court. Because a detainee can be detained 6 months, a year, or 3 years.
We have someone that's been on since January of 2020.
That's been on home
On
detention.
detention since January of 2020.
And what's the average cost to house an inmate per year? Is it 60, 70,000?
In state, it's about 95,000.
95,000, that's high.
A crude calculation.
At one
is to take
person.
the entire budget and divide it by the number of people.
300,000. One person for 1 year to take up an incarcerated bed. At the most, it's 95,000. So we got some more questions. Topper had his hand up first, so Topper, Teresa, and Martin.
Thanks. Could you help me understand, how do you know if somebody is on, is in the home, on home detention?
We have electronic. Because we have electronic monitoring devices that we place on their ankle, an ankle bracelet. And it
So
basically,
out of those 18 that you talked about, how many have bracelets and you're monitoring them?
we only have 6 on home detention right now, and they all have at least a GPS monitoring on. And it kind of works like your cell phone, and we get that readout. So like MapQuest, or we know where you are. The company and the technology for electronic monitoring is amazing. They can pinpoint you really small areas. And really the zone of restrictions is really kind of determined by the court. If it's don't go near your victim that lives at this residence, we can actually put a box around, not really a box, but a virtual box around it. So if anyone enters that box, we're notified. We look at the timeframes. If you have a 10 o'clock curfew, we can see if you're at your house at 10 o'clock or not. So it's really good technology. It's just like with your cell phone, and it can tell me right now I'm in Montpelier, just pulling it up and putting on MapQuest. It's fairly similar to that.
So I think what you have to be careful in the home detention program, you are allowed to leave your home. You have to comply with conditions that the court has set. So those conditions could be you don't go to a bar, you don't go to your victim's property, maybe you don't go near a school. You're allowed to leave your home, go grocery shopping. You're allowed to go to work. You're allowed to go to a friend's house if they're not restricted from those conditions. So it's not that you're staying in your home 24/7. You can keep your job. You can keep your family together, that type of thing. You've got to comply with the conditions of release that the court has put in place. And that's what the electronic monitoring determines. It is passive. So they could go to the victim's home during the night, but your field office may not see that until they come in the next morning. And then you take action on that piece, possibly.
And I think some folks, I think you make a good point, Madam Chair, is electronic monitoring device isn't going to prevent anything bad from happening. It just lets us know. So I can easily cut it off. It's not like one of those sci-fi movies where that like freezes them or shocks them or anything. It just reports back to us information. So if there's a serious victim concern, this will let us know if they've gone near them or not, but it won't stop, anything bad from happening per se.
Teresa and then Martin.
So you said substantially reduced the cost. Can you give us some idea about what that is?
We have it's
$1 a day.
Yeah, it's a dramatic, most of the cost came from the standby status. We have staff on now, we have staff check, so it's just kind of part of their responsibilities. And there would be a marginal cost to have one more person on home detention. There would be some cost time to go out and do the investigation, do the report writing, go to the court, et cetera. But it's marginal, really.
So essentially you can operate it within the existing budget must be because the money was removed, but program exists. Okay, substantial is a relative term. So thank you.
Moving from the active electronic monitoring to passive was a change that we made last session. That was what our committee worked on to say, hey, if the issue is it's active electronic monitoring and you're not able to do it or it's a high cost, let's go to passive and see how that plays out for a while.
And then an additional change that the department made is we expanded our referral process at the time. That was brought up during the session.
Correct, and I'm sure that Judge Zone will get into that because that's where that piece came from. Martin, and then we'll go to Senator Sears.
So let's say that we're able to expand the use of home detention. And these will be questions I'll have for Judge Zone primarily. For instance, if somebody's put on probation and violates their conditions, maybe the next step isn't incarceration, maybe it's home detention. Or perhaps we should expand to allow the courts not just for detention, but as a sentence, having sentencing for home detention. So these are questions for the committee and for Judge Sony, but let's assume that we expand this. My question for Gail is there a maximum number that you would want to have? What happens if all of a sudden this becomes popular and we have 100 or whatever people on home detention? Is there a maximum that really becomes too difficult to
I assume
monitor?
there would be at some point, but 100 we could absorb easily, right? I'm assuming the 100 be spread out through across the state. If the 100, went to Newport, it may be a little bit more challenging. But if it's spread out across the state, I mean, it really monitoring. I think where the cost, if you start expanding it, where the cost I think will start coming in is with non-compliance, because we'll have people cutting off bracelets. That's basically they're about $1,000 each unit. So if we start losing units, that happens now. Would be a cost. Time doing all the paperwork and responding to the court questions and stuff. Now, previous to home detention, when home detention first came out, there was also another status called home confinement, which was basically the sentenced version of home detention. They were both monitoring on electronic monitoring, or they were both supervision electronic monitoring. One was sentenced, one was detained. Through justice reinvestment, home confinement was repealed because it wasn't effective and it cost more money with a bunch of other legal statuses. One of our rationales, as well as repealing, besides the cost of home detention, is that we have a very complicated system. And one of the recommendations from CSG during the justice reinvestment was basically streamline our system to simplify it because the complexity worked against us.
So what was the complexity for home confinement?
It was another legal stuff. I think when CSG started, I think we had 23 legal statuses that the department had to manage. Now I think we're down to 12.
And I think one of the big changes that we made with justice reinvestment too was home confinement was also seen as almost like another status of furlough. For that, and our furloughs, we had so many. What we did with justice reinvestment too is move towards a presumptive parole. So when you meet your minimum, instead of just being eligible for furlough, you would be presumed to be eligible for parole. So you skip that furlough piece and go right to parole. And that was an attempt to streamline it and condense the number of furlough statuses that we had, because we're now going to kick them over into parole. Does that make sense? That's what we did, Dale. That was our goal.
The state added presumptive parole, but that has not really taken off either. I think we have 5 or 6 on. Some of the initiatives that the department made during justice reinvestment is we changed. We matched up our supervision statuses and supervision intensity based completely on risk and no longer on legal status. So someone on furlough, on probation, or on parole with the same risk score as a high-risk individual would be supervised at the same intensity. Other changes, we made a lot of different changes. The department went a few steps beyond justice reinvestment, what was passed. One of the things we did, at their minimum sentence, everyone is eligible for furlough or parole. And historically, everyone would get released on furlough, then at some point make parole, right? Furlough was like the parole training ground, for lack of a better word. We've changed that process. And now every time we send someone out on furlough, for the most part, we do have some mechanisms not to, but for the most part, if someone is prepared for release on furlough, we also give them a positive recommendation for parole, per policy. Because the supervision is the same, and we're pushing to reduce our number of people on furlough. And I think right now we're down to about 250 people on furlough. So that big change was a departmental policy change, where we're paroling more individuals coming out of the facility right from the get-go.
Can I ask a follow-up question?
Yes, and then we'll go to Senator
Just a
Sears.
quick follow. So, I mean, could home detention or home monitoring confinement, whatever you want to call it, be part of a probation condition or a parole condition?
So how it works, they can, we have that in statute already. So the department on any legal status can use electronic monitoring to monitor. What the courts will do on probation is the department has to be able to violate the electronic monitoring device has to be able to satisfy a condition. So I can't put GPS on someone that has no restrictions to movement, right? We can't violate that per se. So we already have that in statute, and what courts will do is they'll give us conditions, and then really electronic monitoring is at the discretion of the department and the commissioner. So I could have all the conditions, restrict associates, whatever it may be, or no alcohol. We can use we have an alcohol monitoring device as well. And then the department will do our assessments and determine if we need that level of supervision for the case. Generally, we follow the court's direction, at least initially, especially if we don't know the individual coming out. But so we already have all the mechanisms for all of our legal statuses to use electronic monitoring. Like one of the reasons for home confinement, it was a pre-men release, but we could do everything the same on our post-men release. So we added a lot of different layers of complexity. And over the past 15 years, the state has really looked at, we didn't build our prisons and build our way out. They were really the state was very creative, and with all these different legal statuses, they kind of keep our prison population reserved for the most serious and the most dangerous.
Thank you.
Senator Sears?
You're on mute, Senator Sears.
I have two questions for Dale. One is, are there ankle monitors that can detect other drugs besides alcohol?
Not that I'm aware of, doesn't mean they don't exist, but I'm not aware of. Right now, the only device that the department uses is for GPS, for location device, or for alcohol.
Okay. If you mentioned that people go out of bounds or go someplace they're not supposed to, and the GPS will pick that up, or if they cut off the ankle monitor, who's responsible for, does the department place them back, or do they have to go back through the court again?
So the department so we have very little discretion making around who goes back. So when there's a violation, we notify the court, and we return the individual to jail. That's in the statute. And then we write affidavits to the court saying this is how the individual violated his home detention. And then the court will make the determination what is the resolution of that. They can release them back on home detention.
Yep. So the department actually can incarcerate somebody that's on home detention.
Yep, correct.
For violating whatever.
Correct.
Okay, thank you.
Other questions? Irene?
Thank you. I'm going to probably piggyback on what Senator Sears just said. On the Agriculture Committee, we talk about electronic fencing and how you can zap an animal if it goes beyond its bounds. And I don't necessarily think we can zap someone on home detention, but maybe an alarm could go off, maybe something else could be triggered such that it's not the next morning we find out this person went and approached the victim's home or something like that. Just technology is ahead of, I think, where we are right now.
But the alarm, would that be the person, would the person receive the alarm, the offender, or
if the bracelet starts a high-pitched sound that alerts the victim perhaps before they're approached or before, when they come within range of that victim's alleged victim, whatever, victim's house, the alleged perpetrator gets within range of their home or their business, or, I don't know, I wouldn't want us to see us, I wouldn't want to see us not use the technology to the extent that I'm seeing it used in other realms. And I just wanted to make sure that we are exploring all the ways that technology can help us in those bracelets, because maybe there's more features, maybe you've already explored that, but I wouldn't want us not to.
I'm not aware of a system that has an alarm that goes off on the system itself.
Okay.
Generally, the individual knows kind of where their boundaries are, so they kind of already know if an individual is going beyond those boundaries. But I think if I was trying to understand your question, that was when we had active and when we had immediate response, and that was where all the cost came from.
Sure.
So it's trying to find that balance to kind of to continue with the system.
So as a follow-up, if I may, I have a friend who works in business with me, and we use this very inexpensive, free app called Glimpse. And I can see when they are in a building and where they are in a building. So maybe providing the victim some sort of facility that they can see where this person is. I don't know if that violates the alleged perpetrator's rights, but again, to keep the victim safe, if we are not doing active monitoring, perhaps that's something useful that the victim could be.
But that wouldn't be DOC.
I'm not an attorney, so there could be constitutional issues. Judge Zoni may be able to better, or I'm the only non-attorney today.
Thank
so.
you. I appreciate it.
And all of us, well, some of us, I don't know if all of us.
Great.
Okay, we got an attorney in the house.
Thanks.
Other questions of DOC? Thank you, Dale. So we're going to switch now to the courts. And we have Judge Zone. And one of the issues also that came up when we looked at this this past session, in the committee, we had Judge Zone with us, and it really looked like a lot of judges may not have even been aware that home detention was a program that could be used. And Judge Zone really encouraged us to keep the program in the toolbox as an option, and work with us in terms of how could we have the courts more engaged in recommending home detention. So Judge Zone, welcome.
Well, thank you. Good morning. For the record, Tom Zone, Chief Superior Judge, and I will apologize. I'm in Boston and I'm in a kind of a public location. So I do hear the beeping, which sounds to me like backing up. I won't back up. I did encourage I did encourage the committee to keep the home detention in place, because the more tools, the more options that we have, the better we can serve the administration of justice, because no two defendants are exactly alike, and we can respond to the cases on a more individualized basis with the more tools we have in our toolbox. After I had the meeting with the Corrections Committee, I did take the message back to the judges. And my message, I think, was pretty direct, that there is a request by DOC to remove home detention from the toolbox, to consider that we needed to have a closer look at home detention, and to expect that DOC was going to be making more applications for home detention. When I did that, I think the number at the time was probably around 9 or 10 in home detention. And Mr. Crook has let you know already that the number is down to 6. I did note that when Mr. Crook talked about the 18 individuals, I don't know if that was, as he pointed out, we don't know if there were 18 people and 2 got in and 16 got denied, because what can often happen is when somebody comes up with home detention and this program's going forward, there is also the opportunity for resolution. And so those cases could have actually been resolved with the person having a sentence imposed at that time. So I don't know the specifics of those situations. Representative Lalonde had asked about maybe using electronic monitoring for violations of probation as a first step. And that is something that is often used by the courts. You can use, when there's a VOP that comes in, they're already in the Commissioner of Corrections custody. What we can do is say electronic monitoring as directed by your probation officer. So that is a tool that can be utilized there. As far as the issue of where do we go from here and the passive versus active, years ago, there was actually a case that went up to the Supreme Court, I think twice, where the judge was concerned about the fact that it was passive electronic monitoring. And the Supreme Court at the time said, no, how DOC discharges its duties is up to DOC. And I know that DOC went to the more active methodology, but I don't know if the passive aspect has had any impact, because one of the concerns the court has to look at, and one of the factors, is the safety issue. And so that is something that could potentially play into the court's determination. As far as the numbers go, they are low, but I think it's been kind of danced around. But I think it was Senator Norris that touched on it too, and that is, well, basically, if we're having $95,000 per person and we have even 6 people out, that's saving money, possibly. So I do think it's something that it's helpful. It's beneficial to have. I wish I had an explanation for why it's not used more robustly. I can't sit here and say it's A, B, or C. I wish I could. But any questions, I'd be happy to address them.
Martin?
So are there any suggested legislative changes that might allow expansion of its use that you can think of? And we did talk about taking out, and I know there's constitutional and other issues that would need to be looked at, but taking out the requirement that the person be bailable, or, are there any other ideas that you have of how we could expand the use of this?
Well, if you're going to expand the use and take out the bail aspect, keep in mind that under 7554, subsection A2D, I believe it is, says that the court can impose any other condition found reasonably necessary to protect the public, except that a physically restrictive condition may only be imposed in extraordinary circumstances. And I think it would be potentially fairly viewed that if someone's on electronic monitoring and can't leave their house, that's a physically viewed restriction from their perspective. And so I think that would be something that you'd have to look at amending. There would also have to be an amendment up above in subsection A1 when you're looking at F. It talks about imposing other conditions, including a condition requiring the defendant return to custody after specified hours. You may want to tweak that. The other aspect is that we've heard a bit about the issue of when you have individuals who are, I think it was Ben Novogrodsky mentioned, placed in the custody of some other person. Well, that is placed the defendant in the custody of a designated person or organization agreeing to supervise him or her. And so I think if you're having electronic monitoring, that would seem to be supervising in a level, and that statute would have to be tweaked too. So I think if you're going to look at expansion, it really might be an opportunity to look at 7554 as a whole and try to see what is the best way to have the issues addressed for bail and recognizance for pretrial release. I'm aware of other circumstances that we've been hearing about throughout the state, whether it's issues of bail, whether it's issues of conditions of release, and this may form a real opportunity to take a look at the whole statute regarding pretrial release and come up with a comprehensive reform.
Martin, your committee and mine are going to be connected to the hip.
I think Ben is saying.
Well, and just a point of information, Representative Long, so I believe it was in 2017 that this program actually did apply to people that weren't eligible for bail. There was a court decision that construed it that way, and then in the bail reform statute or bill that came in 2017, it changed it to make sure that it was only for people that were bailable. Just for some more context.
And that change was effective as, I believe, June 1st of 2018. where the legislature made it clear that individuals held without bail under 13 VSA 7553 or 7553A were not eligible for this program.
So Ben will probably add this to my bill request related to conditions of release. I think this is related enough that I don't need to put in a new bill request. So it's drafting request. I mean, I have one in for a conditions of release issue, so.
So this leads to the conversation for us as a committee in terms of what do we see going forward with this particular program? And do we make a recommendation to repeal it? Because there aren't very many people using it. Or keep the status quo, or look at changing the supervision and who supervises, or really do an in-depth look at the whole section 7554 and incorporate conditions of release and that whole section with looking at reconfiguring the home detention program. That's what's before us to figure out.
Well, and Judge Zone, is there intent to continued education with the judicial branch so they understand the usefulness of this?
Absolutely. That message was delivered again exactly 1 week ago today to all the judges during one of our meetings. I have reiterated it at various times, but I was very clear about it. And after today's testimony, what I will be doing is during our next judge meeting, I will be visiting with the judges about that. I can also let you know that the Sentencing Commission has been charged with coming up with the report that will be filed this week on the question that was posed about elimination of cash bail. As part of those discussions, one of the topics that came up was that there were some individuals in court with low bail. Who were pretrial detainees with low bail. And one of the suggestions was that we start looking at those cases. And so that's also been raised with the judges, and I'm taking steps to make sure judges stay, if you will, on top of those cases so that there is a next event. And some judges are now having cases come back in for review. And so this type of program may be an ideal circumstance for someone to, when it comes in for that type of review on a low bail, this would be something that I think should be seriously considered by the judges. And so you may see DOC having more requests for evaluations.
Thank you. So Judge, when you mentioned this at your judges meeting about really trying to use this tool in the toolbox, what was the reaction from the judges? Did you receive any?
I can't say that I got a strong reaction. I know the view is generally that if DOC asks or defendants ask, that the judges will look at it and consider it. And what I'm trying to do is just shift that a little bit to have the judges who absolutely recognize that this is a tool in the toolbox, but to really highlight for them that perhaps we need to take more of an active role when we're imposing, let's say you're imposing bail in a case, that we should possibly look at it and say, okay, I'm imposing bail today, but we need to get this looked at for home detention. And so I think that just having it looked at from a different perspective may be helpful.
So then my next question leads to what's been testified when there's a referral made from DOC to the courts, like there was 18. DOC doesn't know if any of those folks went on home detention or not. And then the court had two situations that they asked DOC to investigate. Did the court know that those two went on home detention or did DOC know that those two went on home detention? It seems like there's a communication snafu that the court doesn't know who went on home detention and DOC doesn't know who went on home detention, what those final decisions were.
Yeah. And so when I heard Mr. Crook say that, what it caused me to do is take a note, because what I'm going to do now is I'm going to speak with the judges and I'm going to speak with the TCO, trial court operations side. And what I would like to do is start keeping track of every time the court makes a request or every time DOC makes a request, and to have a data chart to say what happened, when was it filed, and what was the result. And so I think that's important data that I'm going to pursue at this time. And I'm really appreciative to hear his comments about that event, because I was unaware that it was that number.
Yeah,
That was just pulling the data. So I didn't track individuals through the system. I said, how many referrals did the department make? And I got that number. How many referrals did we make? So very well, I didn't track individual. I didn't track the 18 individuals and where they went linear. I just pulled the data, the raw number of referrals or placed on it, or et cetera.
and we need to see that connection as policymakers. If there was 18 referrals made from DOC to the courts, and now there's only 6 people, are any of those 6 from the 18? Or were they holdovers from the previous 10 or 12 that were there? You know, that.
And I will check to see if I can potentially go back and get that information retroactively. If I can't, I will get it proactively.
I think we need to be very clear to figure out how we move forward with this. Because the other thing that came up too, if we repeal this program, even though at that time there were only 10 or 12 folks, now there's only 6. If we repeal this program, what do we do with those 6 folks? Because the program goes away, do we grandfather them in? Or do we say, you're a detainee, you have to come into an incarcerated facility because the program's been repealed? That's the other thing we have to weigh too. So where are we as a committee? Because I'm assuming Ben would have to write a letter. Say where we are. Who? Oh, Matt. I didn't even see Matt. Yeah, sorry, Matt.
So could, I guess I haven't heard a strong argument for repeal one way or another. I mean, I think it was the passive active, but I didn't. I mean, can people argue that if or that might be a position? I don't know if POC is advocating for that now.
I'm just putting that on the table because that's what instigated the whole.
But I'm just not clear if that request for repeal is still out there, or is DOC satisfied with having gone to passive for that?
For the record, as the policy director for the department, that request for repeal came from the administration due to the unbudgeted nature of the program. As there's now negligible cost for operating home detention, we no longer seek to repeal it.
So we do have the Defender General with us, Matt Valerio. I'm so sorry, Matt. I just didn't even see your name on the screen. Welcome, and if you could just identify yourself for the record.
Sure. I'm Matt Valerio. I'm the Defender General. I've been practicing here in Vermont for over 30 years, 35 years as an attorney, and I've actually seen electronic monitoring in various forms for decades. This is not a new thing. It hasn't been a new thing. It's just under what circumstances it has been used. And in this particular case, it is, we're talking about home detention. I will say that statistically, we do not track home detention in our case management software. But I did survey our membership, the folks who do criminal law, both under contract and in the staff offices, and they encompass the entire system. And I surveyed our listserv, and basically it confirmed the same thing that you've heard from everybody else, that it is not used very often. There's a handful of cases, or sometimes 2 handfuls, that where it is used. It does tend to be used in more serious cases where other options are not available. It is often used in cases, I'm told, where the lawyers cannot find or locate a so-called responsible adult to be available to deal with the whereabouts of the defendant, getting them to court and the like. And I think part of this, the reason it isn't used as much is because at the same time we started dealing with the concept of home detention, which, by the way, has been there in some form or other without the label of home detention for decades. And I'll get to that in a second. But the legislature in recent years has been tinkering with bail and the availability of bail and when bail can be imposed, um, and has narrowed the window on the number of cases that would otherwise have qualified for home detention over this period of time. So the number of cases is kind of small that would qualify, and when they are being released on other either conditions or on another status. So I wouldn't expect there would be a large number of people who are available for release on home detention anyway. One of the things that we have learned about home detention over a period of time, and this was testimony, I went back, dug through the testimony of the then sheriff from Windham County who did a localized study of what was going on. And then I compared it to a national study of recidivism rates for people who are on electronic monitoring, and whether it is passive or active, the recidivism rate for people who are on home detention electronic monitoring is less than 2%. The overall recidivism rate for general offenders is closer to 60%. So I don't know how you do a value of that, but there is some value there. And what I've heard from the field is that clearly the defenders would like to see it available for more cases, that it shouldn't be limited in any particular case, and that the judge can let the judge make a decision whether or not home detention is an appropriate status pretrial to put somebody on. Now, going back before home detention, there was always the availability for the court to put somebody on a 24-hour curfew. There was always the availability of the court to put somebody on a 24-hour curfew with electronic monitoring prior to pretrial. And so effectively, we had these options available, but it wasn't consolidated into a particular program. The thing that became attractive about home detention was the availability of technology that is so prevalent now. And I was just next to my computer here, I have my cell phone, and my family has consented, but we use something called Life 360, and I have myself and my 3 adult kids, aged 22 to 27, and my wife, and I can pull up Lifetime 360, and literally I can tell you exactly where they are at any time, or at least where their cell phone is at any time, based on this, and it's free. Now, I'm not suggesting that is anything special, but the bottom line is that the technology to track somebody is ubiquitous nowadays. It's everywhere. It's available. This is not hard to do, and a particular and the one that I have that's free here that we use for our family is actually active monitoring. I can tell you I can tell you if they're walking, I can tell you if they're driving, I can tell you within some number of feet exactly where they are. The early complaints, and I recall back in my first term or two as DG, there were concerns about blackout areas in the state and the like. And I recall Representative and later Senator Peg Flory, this was a big issue. They had folks come in and talk about how their technology was better than other people's technology. Those things don't seem to be an issue anymore, because the availability of the technology is so, it's everywhere. So we don't have a technological problem. We're really making a policy decision about whether we want to have certain types of folks or certain people who are charged with stuff have the availability of being out or not. And if this is the reason why we can get somebody out, the defenders, of course, and I've heard the court say the same thing, would like to have this tool in the toolbox, so to speak, to make sure that pretrial people are out pending the resolution of their cases. I will say, too, that electronic monitoring often is a catalyst to getting cases resolved in the criminal justice system, even in the limited numbers that are out there. And it happens in two ways. Number one, if somebody doesn't have a problem while they're on electronic monitoring with home detention, it demonstrates to the Department of Corrections and the court that this is somebody who can follow conditions of probation or furlough or the like, if they are given that opportunity, because they are effectively demonstrating that pre-trial. Number two, it allows a defendant to keep a job, keep a residence, do whatever they need to do to keep their life working appropriately. And that, again, demonstrates to the court that this person is a productive citizen capable of doing the right things and staying on the outside, notwithstanding whatever it was that brought them to the court. And finally, it also demonstrates to the defendant that they are capable of complying with conditions. So if you have somebody who is worried about furlough or worried about being able to comply with conditions of probation or the like, it gives them a comfort level that they're able to do it. All of those things are kind of collateral benefits to home detention that we don't talk about as much. We talk about, can we save money having somebody on the outside versus on the inside? But what you might actually be doing, and I haven't been able, nobody can really quantify this at this point unless there was a study, but I do know that these things are good factors for a defendant, keeping them out of jail in the long term if they can demonstrate their ability to be productive and not engaging in criminal activity or violating their conditions while they're on the outside. So, the cost issue, I think, has effectively gone away for the Department of Corrections. It's unfortunate, frankly, that they somehow lost some money, but kept the program some number of years ago. There's a couple of those things that I'll end up talking about with the Appropriations Committee that occurred with my budget in the last couple of years too, but I know how things get at the end of a session. It was likely an oversight when you're talking about a $200 million budget for corrections. Nevertheless, I'm hoping that home detention stays in place as an option, and that it's actually made more available to other folks who are being held on small amounts of bail or bail in general, so that that could be another release valve for the system.
Thank you, Matt. Questions?
So, thank you, Matt. So why isn't home detention being used more? It seems like there's all sorts of benefits and it's hardly being used. What's your perspective on why?
It's the key. The key is the part that I said at the very beginning of my testimony, is that the legislature over the last period of years has tinkered with the bail statute and when bail can be imposed and how much bail can be imposed and the like. And there are a lot of other options to get somebody out. And home detention is kind of like the most restrictive option that is out there. And so necessarily it applies to a very small number of cases, that people who don't qualify for having a responsible adult or who are not bailed otherwise It just is a relatively small number of cases where it's appropriate, and the statute specifically talks about the least restrictive conditions being available to ensure that somebody shows up for court, and where it's appropriate to also relative to protecting the public. There are other conditions and there are other ways that people are getting out. And so it really limits the number of cases. You know, if you doubled the number from what it is now, that almost would surprise me. I think it's a small number of cases that you're going to get. You're probably not going to get more than 40 people who would be dealing with this anyway.
So I guess it seems a bit of a disconnect in the fact that there's, from what I understood, 430 in-state detainees right now that are being detained on bail, not posting bail was my understanding, or did I misunderstand that?
I think that number is more than
That's the total that's held without bail as
Usually,
well.
the majority of folks are held without bail.
What, do you know what the number is offhand as far as on bail?
It's usually like 60% on bail.
I think about 200, give or take, are on the bail, held without bail, give or take.
So you'd have 400 that would be held.
So there's a lot of people being held on bail.
200 and some held with bail. But then you have to go into those bail amounts, don't you? Because that would determine the level of risk or.
Well, that's not supposed to be.
I know.
It's just an incentive for them to show up, presumably.
Right. Risk of flight.
Risk of flight. And with home, yeah, it just seems like with 200 people being held on bail, there's a lot of room to expand.
Well, I think that if you broke down those numbers, there might be significantly less than 200. I mean, oftentimes you have people who are held on bail concurrent with probation violations, so they're getting concurrent credit. You're getting people who have multiple charges who have concurrent bail. There, you know, when you really break down that 200 people, I think you're going to find, and then you look at what the statute allows home detention to be used for. I think that you're going to see a number probably under 100. I think you might not have that many really being qualified. I'm guessing that it might be 75, maybe 60. And then it all depends on what else is going on with the case. When you peel back the onion on these things, I don't think you're going to see that there is a huge number of people who are qualified for home detention who are not either applying for it from the defense perspective or from the, with a defense motion or with the Department of Corrections using it. I think we could do more than we are, but I don't think you're going to find a particularly big number. But I guess that's worth looking into. I just don't have those stats available. The department probably does better than I do.
I'll work with that. So, and maybe this is a question for Department of Corrections. Can we unpeel that onion and see what the different categories are? And maybe there's a category there that we have to amend the legislation to allow those individuals to be home detained. That was a question for you.
Well, that's a question for me. I think that could be one of our recommendations, and I don't know if DOC could answer that.
I can tell you bail amounts. This individual is held on 200, 1,000, whatever the bail amount is. But we can't, that would be on the court side to say, why is that person given that bail? Like, those are all individual decisions made. We just kind of say we have, that's right here. We can say we have 200 and.
This is as of September 25th. Of the 454 individuals, 229 of them were held without bail.
But I guess I heard from Matt that they could be also on being held because of a probation violation. So, I mean, if it's just, I mean, are you able to say that these individuals are only because of not posting bail, or are there other reasons they're being held? I think that's what I understood.
For this number, it would be for people that are detained, and the detainment is based on bail. So they're not sentenced detained, that's a whole different category where someone has bail, but they're also sentenced.
So they wouldn't be counted as a detainee then,
They'd be counted as sentenced.
as a sentence detained.
Yeah.
But these are strictly detained,
Yeah.
no sentence. Do you have policies or directives that carry out the home detention program?
Yeah.
So we'd have to look at those directives because that determines a little bit more in terms of who might qualify for home detention or not.
It really just tells us what our responsibilities are. It doesn't really say, that is for the department staff to follow, is our policy. It's right online, anyone can look at it.
Yeah, so, because sometimes it's your policies within your directives that really determine the nuances when you start peeling the onion. That's what I'm trying to get at.
Yeah, so, and just traveling through this a little bit, what IT do the courts have, or does DOC have, or does anyone have to track those individual decisions? So you said it's difficult to follow longitudinally and look at an individual through the decision-making process. It's hard to follow. I'm asking, is it hard to follow once the court has made a decision about who's on home detention? What happens to them? What are the conditions for the court decision? So how do we follow these folks? Is this a written record? Is it an IT digital record? Is there anything that we have that can help inform us about the outcomes based on the decisions that are made? I don't know who I'm asking this question of. Could be Judge Zonay, it could be Matt Valerio, it could be Dale Cook. Just a general question about record keeping that's probably beyond some of the.
Isn't the real question just who's eligible, who's not getting it?
Okay.
I mean, and then the next question is if that, if we identify who those people are, why aren't they?
That's a better question.
That's a better question. I think it can be explained a little bit in terms of their directive, is the DOC referral process. And the person that would qualify for home detention is detained for a non-listed, non-violent offense. If it's a listed or violent offense, they would not qualify?
Those are the ones that the department makes a referral. Everyone is eligible for home detention that has bail, no matter what the offense is. We have someone on for attempted murder right now. So those are the referrals the department has made. So the department makes a referral. We have our criteria that we set up for the department to make.
Right. This is a department referral to the court, because the court makes the ultimate decision if someone's on home detention or not. So what DOC is going to refer to the court are those detainees that have a non-listed crime and non-violent offense. So those with listed crimes and a violent offense not be referred by DOC to the court for home detention.
Correct.
That's what I'm trying to get through.
But they're still eligible.
They're eligible, but they're not being referred by DOC to the court. So that feeds into what Matt was saying, that you've really got to look into those 200 plus that are being held with bail. How many of them are there for a listed crime and how many are there for a violent offense? That the DOC would not refer those folks to the courts. Yeah, yep.
I don't know if this captures everything you're looking for. S14 from last year does include in the report bail rates, including detainees held without bail, with bail, their monetary amounts, and those who post bail and are released. Pretrial detainees held in Vermont correctional facilities, including the crime type and jurisdiction which they're held. So I don't know if it gets at this really specific population of those who are referred by the department, because they're technically pretrial detainees, but whether or not sort of there's a successful aspect to it. I don't know, there, another part of that report is evidence of desistance, which this could potentially fall under if they are successful in some sort of rehabilitation, for lack of a better term.
It's getting more complicated. Welcome to this program. Senator Sears, help clarify. You're muted.
I was trying to unmute myself. I may confuse things actually, but I think what we should do, the legislature, should recommend that we look at what are, the requirements to be eligible for home detention and not, we may decide that just simple bail is not enough, that anyone is eligible who hasn't committed a listed crime, or maybe some listed crimes are eligible. But I would like to know if there's any victims or state's attorneys have a role in any of this.
Right.
Do they get to say no, or do they get to say this is not a good idea? Now, I would hate to do this to expand in any way without the state's attorneys and the victims agreeing. And the case I mentioned earlier about a person who has kept his job, et cetera, the victim was all for it. And she was actually one of the ones who suggested that he stay on detention and that, he make, family arrangements, et cetera. So it worked out because the victim was amenable to it. And I'm just curious if there's any role for the state's attorney or victims in this decision.
Well, that's a good segue to Tim for our sheriff's and state's attorney.
Oh, I forgot he was here.
I know. That's what happens when everybody's on Zoom. You kind of don't see the little squares sometimes. So Tim, we're going to get to you. To answer that question, you were due up next, and I know Martin you're good. So let's segue to the Department of Sheriffs and State's Attorneys for that part of this, Quagmire.
Great, thank you. And Tim Leaders-Dumont from the Department of State's Attorneys and Sheriffs. And I chose the Matt Valerio path here of going last so I could hear all the good comments. And I largely, he's pulled that on me a couple times, and I largely adopt really what the Defender General said and what the Chief Superior Court judge said, in that it's an important tool. Cost-wise, you guys have gamed out on the record today that it is still less expensive than incarceration. And some very serious cases, the 6 that are currently on home detention are very, very serious cases. And, I think with absolute respect to the administration of the Department of Corrections, we have had concerns from state's attorneys about passive monitoring. And I will just state that there. I'm not going to dwell on that. Maybe we could find a happy medium in the future. Maybe it's moderate monitoring. It's not active, it's not passive, something in the middle. And I just wanted to state that as it's something I've heard from our field. And really, Matt and the judge are very correct in that the pathway and the multiple bridges you have to take right now under the statute to find your way into home detention is pretty narrow. That said, there probably is many more individuals that could be eligible. And I was looking at the same data that Isaac had mentioned, and that there was 229 people on hold without bail as of September 25th. The one thing I wanted to mention about low bail is that it's a really fluid process with respect to low bail, and that it could be set, met, struck, reimposed, all within 48 hours. And so when you look at a snapshot of what I would call low bail, let's call that less than $1,000, although $50 could be a lot for a person. But let's say that number, as of September 25th, that snapshot at a particular time that DOC provided, that could be different 1 minute later, because low bail moves very quickly. It's potentially easier for family, friends, et cetera, or the individuals to make bail. One of the hurdles in the home detention is you have to have an inability to pay bail after bail has been set. And so you could work on amending that concept of inability to pay bail after bail has been set. It could provide for a more expedient opportunity for review if you don't have to prove inability, just that bail had been set because of the low bail fluidity. Another thing you could look at, and these are ideas not sanctioned by the state's attorneys, but just ideas because we're talking about this today, is the concept of, detention pre-trial in this context applies in the home detention context, as Dale pointed out, applies to anybody that could be subject to bail, and in fact, where bail is imposed. And not to confuse things, but in the imposition of conditions of release, which are non-supervised, Ben had brought up the custody of a designated person, referred to in the field as a responsible adult, or a quote number 4 person, because of the way it's situated on conditions of release. It's number 4. In that context, that only applies to a double negative. That is not a nonviolent misdemeanor or nonviolent felony. So you couldn't put someone on a responsible adult for a DLS, for example. So that, if you are going to play with the statutes for home detention and make sure, as the judge suggested, that they marry up with 755 for the bail consideration, you just want to make sure that it's being inclusive as to your desired intent. And also, lots of folks, as the Defender General mentioned, if they're coming in for, let's say, a $50 arrest warrant, they get brought into court and they have a DLS or a bunch of nonviolent situations, the resolution might happen that day because they've already spent the night in jail, they're coming in. And so resolutions get driven by appearances in court. And so that's another way that bail is a very fluid concept in the low bail environment. But I do think this is an important tool in the toolbox. And the one major distinction, just to continue to hammer home, is that with the responsible adult, it's not supervised by the state employee, and certainly in home detention it would be. But the ability for the individual in home detention to acquire credit, I believe, is an important aspect of this program. So the individuals mentioned, the 6 individuals are acquiring credit right now, I believe. And so that's an important process in the resolution disposition of the case. Or if an incarcerative term is imposed, and let's say it's 3 to 5 years, however long they've spent on that, they could get credit for that, presumably. So I'm providing hopefully technical comments as opposed to a real position, but I think most of our state's attorneys agree that the more tools that we have, the better. Even if it's a low number. And right now, the statute, getting to your question, Senator Sears, provides just that the defense, the court, or the Department of Corrections can ask for this referral. And so states' attorneys are more of a backseat observational space here. And that is what it is. I don't know if I'd be asking for us to be more involved in the process, because certainly defense attorneys have the best awareness of potentially how their clients might be served, and the Department of Corrections runs the program. Well, that's really my comments, and happy to answer any questions.
Questions, statements, folks? Bob?
You tell us wintertime, we seem to be spinning our wheels, so we haven't changed our wheels as of yet. I haven't heard anyone talk against the program. Okay, even DOC's removed their request because they've gone to a passive system. And I guess I would think that once House Corrections and Institutions and House Judiciary goes back through and looks at 7554, this should be something that we revisit, whether or not, I don't know if we put a sunset on this or a timetable or something, but I haven't heard anyone speak against home detention program. So I think that if my opinion would be to leave it as is, have the House Judiciary and House Correctional Institutions go through 7554, take a look at it, bring it back, and let's see where we go from there. But I think that Judge Zone had mentioned that he spoke to his folks. We want to see if this is something that they are going to pursue or continue, and actually, and there may be some little glitch in there that the two committees can look at and straighten out this problem here. But I guess that's my take on this whole thing.
I was going to say the same thing, only you said it much better.
Well,
So let's give some direction, because Ben's going to have to draft something here.
So the one thing I've had to, Senator Norris, is a request of CRG to dig into some of this data that we're talking about, of who's being retained.
That's the crime research group.
Crime research group. But they've already been presumably doing the research or gathering information on S14, but we can ask them specifically for this information that we feel we need to further understand the eligibility criteria and whether there should be changes. I don't know if we need to do that through this committee or.
Well, I think what we should, I'm just thinking of, Senator Sears.
Well, I just wanted to echo Senator Norris's suggestion that the House take the lead, but if you really would rather,
You're welcome, Senator
really
Sears.
rather that the Senate Judiciary Committee look at it first, that
Yes.
I'm fine, but I do think your House Corrections Committee has done extensive work on this issue in the last 12 months, and I'm appreciative that judiciary is willing to help you with it. But I'm fine with either way, whatever you all decide. But I think Senator Norris's suggestion is a good one, and then we will take a look at what you come up with. But I'm not ready for legislation today. I think we really need to review the program and make sure that everybody who should be eligible is eligible. And that may mean looking at, certain people who are in, who've allegedly committed certain crimes, but also looking at the probation population and violation of probation. I think one of the things that I would like to see us tackle this year is certainly conditions of release and the violation of those conditions. When we change under Justice Reinvestment 2, it was never our intent to not hold people accountable for those violations. And I think, at least from the public perspective, we are not holding people accountable anymore. And I think that's part of what I'm hearing from many of my constituents. And that is something that Senate Judiciary Committee is going to tackle early on. I certainly want to better understand all the laws regarding bail and violations of conditions of release and so forth. So I think it'd be a joint effort, but we're definitely going to look at conditions of release and the violation of those conditions and how we hold the people accountable for violating those conditions.
It's going to be a big discussion all session long.
I think so.
Whole General Assembly. Okay.
No, I'm good. I think Senator Sears, I was just going to ask if we wanted to include some of the details that we heard today in the letter. So those who are eligible. Yeah, right.
I think we need a roadmap.
Yeah, a little roadmap.
For that. So this is what I have kind of put together. I was really appreciative what Tim just said, that the pathway to getting to home detention is pretty narrow. And I think that statement is good to include in a letter to the committees. And some of that to look at is right now is the inability to pay bail after bail has been set. Should that be looked at as a condition, or do we expand it to anyone who is on bail? Do we expand it to crimes that are the listed crimes or violent offense? Because right now, only those that qualify, the non-listed, or those that are referred from DOC to the courts are non-listed and non-violent offenses. Do we look at that referral in their directives to maybe change that? Do we separate the whole issue from bail? That's the other piece that came up. And also who supervises? Could it be a responsible adult versus DOC? Could you just leave it as DOC? And the other thing that I think the judge recommended is maybe look at Title 13, Section 7554 as a whole. So that's what I've come up with. I don't know what other folks have come up with that I've missed or stated incorrectly. Keisha?
Yes, sorry to have missed so much, and it sounds like it was captured. It sounds like perhaps there was discussion that if somebody can pay for bail, and that means they're under no supervision versus somebody who is not a big enough threat to be held without bail, but has to be home and monitored, that at some point, the question of who can pay for bail and who can't is all called into question about, equity and what that means. So if that came up, then I'm encouraged by that.
Other thoughts, questions? Ben?
Yeah, Representative Evans, just so the way that this portion of the review was written is that the committee, if it has any findings resulting from its review, it would be in the form of proposed legislation. What I'm hearing is that there aren't any findings.
No.
So therefore, in my view of this, the committee can do what it wants, if it's a letter or something else, since there aren't any official findings that the committee is distilling down.
I think our findings is that this is very confusing. The respective standing committees to really look at it. I think that's really where we're at. Irene?
I'm on another committee that's looking at accountability and measurability, and I wondered if it's helpful at all, as we look at the data, to consider what would it take, what changes would need to be made to have 100 people in home detention within the next 18 months or something.
Cost,
Yeah, the cost. The cost.
comparative cost.
So would a cost analysis to be included of these potential changes that,
I'm just looking for a target number so that, this narrow pathway becomes wide enough that at any time in the next 18 months to 10 years or whatever, we could consistently have 100 people on home detention if we decide that's a way to save money by moving people out of incarcerated facilities.
I think it's a good idea to have a cost estimate from joint fiscal on what it costs to run a passive versus a, I guess, non-passive system. And also what it saves the Department of Corrections. It seems like the argument to do away with it was it was costing the department money, but on the other hand, having people incarcerated costs the department money. I don't know which is which in terms of savings. So I think it'd be a good idea to have joint fiscal look at the potential numbers of people who might be eligible under different scenarios. And if 40 people are available at any one time, what would it cost to run the home detention program, and what would it cost to have them incarcerated instead?
So I think you can combine that piece, Ben, with the cost analysis of joint fiscal office, but also go back to what Martin was talking about, the crime research group, to look into the data that would also help Irene in terms of if you can combine that data with a crime research group, whatever data you want to get, Martin, from CRG, and match that with joint fiscal office doing the analysis of the passive versus active electronic monitoring, as well as avoided costs in DOC if they're on detention, home detention versus taking up a bed, and you combine all that, then you get to where Irene is talking. That's what I'm thinking.
Representative Lalonde, what are the particular data points that you are looking at from CRG, do you think?
I need to think a little bit more about that, but I think the main is who's being detained, the amounts, what the crimes are.
The amount of bail?
Yeah, the amount of bail, the alleged offense.
So right now, there's 257 individuals that are being held without bail.
I think there were 230 some that were
with bail.
With bail. I think those are the main, I mean, if there's other reasons that they're being held, but it sounds like that's a separate category, right? The sentence and bail.
These are non-sentenced.
Right, these are non-sentenced.
These are all detainees, non-sentenced.
So it'd be non-sentenced that we would want to.
Well, does it count in your count, Dale? Are you including probation violations?
If they are held without bail on the violation, they would be counted as a detainee.
So maybe we should look at the number of probationers being held without bail as well.
Put that down for CRD.
That might be captured in S14 when they're reported.
I don't even want to think about this 14.
Well, there's going to be some crossover with that report. So CRG might be doing some of this work already, which
May help.
is a plus.
Yeah.
Yeah.
Anything else before we finish up this morning? I know this was a long morning for home detention, but when we were setting up the agenda and the schedule and looking around the room, there were only two of us that were here during when home detention was put in place, Senator Sears and myself. You were here? Did you work on it too? Well, sort of.
Yep.
Oh, I forgot about
With
that.
the sheriff from Wyndham County.
County,
Yeah, that
yes.
was a big deal.
And then Matt Valerio was here as our Defender General, but the program would be new to all of you. So I knew it was going to take some time to come up to speed, to understand the program, to figure out how we move forward with our recommendation.
Well, can I add one other thing to what should be looked into? Are there, like when the sheriff from Wyndham County was actually monitoring system, are there others who could monitor and then inform the Department of Corrections if somebody's out of bounds, et cetera,
Right.
rather than having the department try to have somebody on duty 24/7 to monitor? I believe in Massachusetts, they do that. I hate to mention privatization, but evidently they do it that way.
Hire it out.
Well, the monitoring, the actual monitoring piece, not the not the enforcement.
Yeah.
Yeah. That's part of alternate supervision.
Is that like alternate facts?
Alternative facts.
So just make sure that I have all our bases covered. So in this letter, recognize that the pathway to qualify for home detention is narrow, and to maybe examine an expansion of that path, to look at the inability to pay language, and maybe to expand to listed crimes, violent crimes, to separate home detention from bail altogether, and examine who is the supervising entity or individual, examine 7554, the bail statute as a whole, to do a cost estimate from JFO to analyze passive versus active monitoring, and then the cost of if it's expanded to include those other crime types and supervision and people who are supervised. Have CRG look at data regarding who's eligible, the crime types, the bail amount level, and the offense, in addition to pretrial detainees and those who are probationers who are held without bail, and I guess the level of return for them. And then finally, who could monitor other than the department.
And I think the other thing we wanted for JFO was to look at the cost of home detention, if someone's on home detention versus the cost of a bed, incarcerated bed. Teresa?
It feels like we should say, like right up front, that we see no evidence of that we should discontinue this option. I mean, that should be the sort of the conclusion, and that we should look at further modification and potential expansion.
Keep the program in.
Yes, that's the conclusion we've reached, I
Yeah.
believe.
So if we could have that ready, we're meeting again on December 12th. And if we could have that ready for our next meeting and go over that, that would be great.
Yeah, in the meantime, I'll draft something up and I'll send it to you and Senator Sears for preliminary review.
Okay. Anything else on this? I think we beat this enough. So, it's noon time and we're due back at 1 o'clock. Dick, was that you? Nope.
Yep. Yeah, no, fine. I was just gonna say, a good chair always keeps us on time, and good job, Madam Chair.
I learned from the best. So we'll be back at 1 o'clock and we're going to be going through H-222 that came out of the House Human Services Committee. Did it get signed? It was Act 22, right? And it's looking at reducing overdoses. And then we're also going to hear from Eric Fitzpatrick about raise the age and the big 12 offenses and how that law works. So we'll see you all back at 1 o'clock. For folks on YouTube.